pulse, like someone feels a pulse on a wrist or on your neck, to check your pulse rate. That bump, bump. And of course we know it was probably bump, 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 bump. It was probably very rapid. The apprehension and the fear of this child. Something made her so afraid that she got a hold of his phone, somehow got a hold of his phone, and dialed 911. Her mother, Felicia Demerson, told us she had had a cell phone of her own. It had been taken away from her. Ebony Wiley told us this whole issue about her stealing cell phones, that she had stolen some money to buy a cell phone. Miss Demerson tells us her cell phone was taken away from her. She was a 9-year-old kid, but she knew how to use a cell phone. She had that technical savvy, like most kids do today. Most children can use computers and phones better than any of us by the time they're 9, 10, 11 years old. But that's what happens when someone's in a great deal of fear, when they're desperate. This man did something to make her feel afraid, to terrify her. But yet she had the opportunity to get his phone. Counsel suggests to you that maybe she got his phone and she bribed him. Maybe something else that's not nefarious happened, because the last person to be seen alive with this child, 15 minutes later, a 911 call is made not from the boogeyman's phone number, not from Ebony Wiley's phone number, from his phone number, from his phone, a phone that he had with him all the time, the evidence in this case proves to us. A phone that he carried with him throughout that night. And he tells the police that he had his phone with him. The same phone he had on the Instaloan video the next day. Remember, he's walking, talking on his phone, and we know he's communicating with Rob Staley from that 288-3413 number, 727 area code. No, this 911 call was made from his phone, not from anybody else's phone. This little girl was left alone with this defendant, not with anybody else. Out of all the people in this country, out of all the people on the face of this planet, it was this defendant and his phone that 911 call was made from. 15 minutes. Not 3 hours later, not a minute later, 15 minutes later. Time for him to do something to this little girl that made her so afraid. And remember what Ms. Demerson told us? She knew how to call 911. And she wasn't shy about getting someone's phone if she was out in the neighborhood to call her mom and tell her where she was. This little girl that we know from the evidence didn't run off overnight. We heard that yesterday in the testimony of Detective Kelly, who spent the entire day with this family, going through all of the roller coaster emotions they must have been going through on that Saturday with their sister and daughter missing, and all the emotions they must have been directing towards the woman who had taken her from them and lost her. This defendant had an hour-and-a-half interview, and he could have told these detectives at any time if this little girl had taken his phone and was bribing him or had done something untoward with his phone. But what the evidence shows is this defendant didn't even mention, he didn't even bring up this 911 call in that interview. And he had all the time in the world to talk about the 911 call. He had all the time in the world, this defendant, who was there with Ebony Wiley, who was there with Felicia Williams. He had all the time in the world in that hour and a half to tell them, and this person would know better than anybody, the defendant would, because he was there by his own admission, whether Ebony Wiley did anything to this child or harmed this child. He could have told those police officers, and he didn't. In fact, he told them, she's a nice girl. She's a wonderful person. I could see myself with her. I told her I love her. In fact, he tells these detectives candidly, told her I'm going to marry her. Which we know he did because she put his name in her contacts as my husband. And we saw that in the evidence in the download from her phone. No, there is no other explanation for this 911 call. And the evidence proves that crystal clear. This was a nefarious situation. This girl was in fear. She was terrified by something, yet she had the ability to pick up that call. So what was going on? Had he taken her clothes off at that point? Had he tried to kiss her? Had he fondled her? Did he go into the other room to get a condom from the package of condoms we saw laying in the bedroom? Something happened between the beginning and the continuation of the attack that led to her death. Something that allowed this little girl, smart little girl, to get this phone and to make that desperate cry for help that you can hear in that call. She's saying, help me, protect me. And Tiffany Morris responded out there, Officer Morris, and she responded to the 124 Bullard Parkway Tower because that 911 center relies upon the same scientific technology that the CAS team from the FBI does to investigate crimes like this. The reliability of cell tower, historical cell tower information. They sent her to the latitude, longitude coordinates right there at the fire station right across the street from Doral Oaks. She came literally within yards of where this little girl was. The only thing separating her from the little girl were the walls, the concrete, the plaster of the Doral Oaks building itself. That was the only thing that kept her from seeing this. She was within walking distance. She was within a rock's throw of this little girl. And that's what the evidence in this case shows. No, this was just Felicia and Granville Ritchie. They were the only two people in that apartment. They were the only two people near his phone. And certainly this defendant had no reason to call 911. It was only through the keen eye of Tom Carroll that we even have this evidence. He took screenshots of the defendant's phone, and you remember seeing the screenshots of the text messages and a call log. And he saw the non-emergency number, the callback number, from the Temple Terrace Police Department. Sometimes the devil is in the details in these cases. The same defendant who was left alone because counsel talked about there's no evidence that he murdered Felicia Williams. He's the last person to be seen with her when she was alive. That's not evidence. And he's not just the last person to be seen with her. He's not a sixth grader in 2014. He's not a child. He's not his mother. He's not the father or the mother or the sister. He's a stranger to this little girl, and he's an adult who has care, custody, and control of this little girl, who's completely at his mercy. From that point forward, she's never seen alive again, ever. And we know the investigation done by the Temple Terrace Police Department in the surrounding areas, how they blanketed that area, canvassed every single person that lived in the Doral Oaks apartments, went back multiple times, talked to people they didn't see the first time, people who didn't answer their doors the first time, talked to people on the streets, passed out flyers, went to businesses. They tore that part of Temple Terrace apart over the course of those 12 hours. And even into the following days, looking for her clothing once they knew that she was dead and had been recovered in the bay. If anybody had seen that little girl, we would know that. Felicia Williams walked into apartment 721 around 4 o'clock, about 3:50. She never came out of there alive. She came out of there in a suitcase, and we know that for a fact. That suitcase, this defendant's idea of a coffin, was utilized to bury her in a watery grave just hours later after she went in there. Can you imagine that? A little girl with her whole life ahead of her walks through a door, and it seals her fate. That is how brutal this case is, how brutal this crime is. Let's talk about scientific evidence, true scientific evidence, evidence that doesn't lie, evidence that can't be cross-examined, evidence that can't be impeached. Evidence that doesn't have a bias, truly scientific, unbiased evidence, not like Dr. Anderson's testimony yesterday where he kept claiming to be an unbiased scientist, and yet he was everything the contrary. This defendant had exclusive control and access to that Lexus GS 400. It was his car, for all intents and purposes. That was his car. Calissa Kelly sat at home most of the time, even though she didn't really want to tell us that. Everything came out of her fairly reluctantly. She didn't make speeches like Dr. Anderson did, but she was just as non-responsive. Anything I asked her, she would basically try to take the contrary position. But she had to admit the defendant left her high and dry on that Friday morning to take his mom to work. He came back. They were going to go to the Insta loan to get the loan that day. And he left her, stranding her at the condominium in St. Pete that she lived at on Tyler Place. Just like he did probably most of the time from the evidence. We know that because Ivy Van tells us this defendant picked her up in January in a Lexus, a silver Lexus. He had been driving that car for months. It was his car. He kept his suitcase and his belongings in that car. He treated it as his own. That's pretty much probably why he was in the relationship with Calissa Kelly, to have a car. He got something out of every single one of these women that he manipulated and used in this case. He was doing it for some ulterior purpose. But he had full, complete access to that car. And he says that to the detectives in his statement. There's no dispute about that in this case. There's no issues about that in this case. We don't have to attribute him to that car in any way. That's his car. He was driving it. I went and picked up Ebony at work. We went and picked up Felicia. She happily jumped into the back seat. I drove up. She said she wanted Checkers, which we know that's a bull-faced lie. They were going to go to McDonald's. That was his idea to go up into Temple Terrace. And in fact, the first thing that Miss Wiley tells us that he said was not McDonald's or Checkers. We can have my mom's cooking at the apartment, because his ultimate goal was to get her into that apartment and get rid of Ebony. So in any event, he says he drove them there. They went to Checkers. They went to the apartment. He tells the police the little girl walked out while they were having sex. And then later, after Ebony drove the car around the parking lot and across the street to CVS, nowhere else, according to the defendant, which we know is an absolute lie, because we have video evidence of Ebony, and we have two witnesses that put her in East Tampa buying marijuana. But we know, other than her driving to buy the marijuana, this defendant is in control of that Lexus. That's the only time he loses control of that Lexus. That's the only time he allows anyone to drive it. And that's so that he can get at Felicia. Another manipulative technique. Other than that, he has that car, and he says to the detectives, I drove Ebony Wiley home. And later I saw her with her brother, who was Kenny Shelton. Not her real brother, but someone who was like a brother to her. And you saw Mr. Shelton come here, the kind of big guy came in. All of that's corroborated. They did go back to the apartment complex to get the address. And Ms. Wiley told us, she told the defendant, the police are coming. Now, the defendant doesn't tell the police that. He says, all she told me was she was talking to the police, because Rob Staley keeps asking him, why didn't you talk to the police? Why didn't you meet with the police? He's like, I never saw any police. That's not believable. There were already police just around the corner, at the corner of Bullard and 56th Street. This defendant slipped out once he was told they were coming. He was waiting, and I'll talk about that in a few minutes, about what he was waiting for. But there's no doubt he has access to that car, and it's his car. He tells the police, I drove home to St. Pete after going out to Williams Road on Thanatisassa, which is the same thing he told them on Saturday was his whereabouts, which we know is false from the cell phone evidence that puts him in St. Pete, and from Calissa Kelly, who says he never left, other than going to the Insta loan with her. That's his big alibi, going out to Thanatisassa to Williams Road. But he tells the police he was driving the car that night. He got up that morning, he drove her to the Insta loan, and he left there and drove to them, to Hillsborough, where the car was finally taken away from him, at least later, when it was seized. So he had full access to that car. He was driving it that night. And we know after it is seized, Terry DeWitt does a very thorough job of processing that car. Thorough to the point, it's not moving now. I think it's froze. Third, to the point of finding that little teeny piece of plant material. All right? So, thank you, Ms. Blevins. You all can see it. You've seen it before, the little piece of plant material. What's incidentally, notice, and I have a better slide of it in my PowerPoint, and it's kind of out of order now, but it's green. It's green. It's recently taken from its place on a plant. It's not dried up, it's not brown, it's fresh. That little teeny piece of plant material that was later examined, we know was white mangrove. There's no dispute about that. We had 3 real scientists come in here that do real research and publish real research papers. People who go out into the field and collect samples of mangrove and research it. Real scientists who follow the scientific method, not physicians. Not that they're not important. They're experts in what they do, but they're not scientists like Dr. Anderson tried to portray himself. In any event, they examine this, it's white mangrove. And we know the area where Felicia's body is found is surrounded by mangroves all up and down the Courtney Campbell Causeway in that area. We also know, let me see, that the defendant's phone, the phone I've already talked about, that's his phone that he has with him when he's with the police later on the 17th. We know from Justin Fleck's testimony it had to be in this area where this purple shading is. It had to be there on the right-hand side of the screen. I guess it's blue on that screen. Because to the far right of the screen there, that little red dot is that cell tower sitting just on the edge of Old Tampa Bay, the furthest most western point of Rocky Point, sitting on top of that hotel. It had to be in that area, and you'll see, and you remember the testimony, the area is dissected basically right down the middle by the Courtney Campbell Causeway. The rest was water. He was on the causeway. Now, if you recall, and you'll see a slide of this later, the cell sector is facing west. It's facing that direction. He's in the western sector. He's not in the northern or the southern. He was in the southern before, earlier, when he passed through the southern sector, which faces down to the south across the peninsula of Rocky Point. He's in the western sector. And we know that's at 12:11 a.m. on the 17th. We know that right past that, he starts activating on towers just to the east of that and to the south of that, back on that tower that's south of the airport, and then he's facing west out over the Howard Franklin. So we know when he's in that zone, which he had to be, his cell phone, when it was making that phone call to Ivy Van, where he was telling Ivy Van that he was ready to pursue their relationship and he wanted to come up and live with her and move out of state after just dumping this poor girl's body into the bay. We know he's heading to the east back to Tampa because he activates on those other 2 towers further east of there. That tells us his directionality. And finally, we know from another scientist, Dr. Christian Wells, who's a forensic anthropologist who has been doing geochemical analysis for years, is an expert in that area, that sand recovered from the passenger side of his car matches geochemically the unique signature of the sand recovered. I think I have a shot of that here, of that area right there where Felicia's body is found. No other area, and it excludes itself from the beach, from the sand from Belcher and 60, and from the sand on the other side of the Courtney Campbell. It is a 99%, and I won't get into the 99.59 or 95. I inverted the numbers like I inverted the 3413 or 3414 number with Detective Carroll, but 99% match to that sand. All of those scientific areas those fields, and the evidence that come from them, they all interlock, and they all match up. And they all paint a mosaic in this evidence of guilt, of this defendant's guilt, an irresistible mosaic of guilt. On this evidence alone, he is guilty beyond any doubt. There is no doubt. This evidence alone is enough to convict him. All day long, he's guilty on this evidence. But there's other evidence in this case. Sexual battery. I want to talk to you about it. The state has to prove three elements to prove the defendant's guilt of sexual battery. The first one is that the defendant committed an act upon Felicia Williams in which his sexual organ penetrated the vagina of Felicia Williams, or he committed an act in which the vagina of Felicia Williams was penetrated by an object. The victim is less than 12 years of age, and the defendant is older than 18. That's just a copy of what you saw yesterday. We know he's 35 at the time. We heard that evidence. We know she was 9. That's not an issue. We know from Dr. Alexander, Randall Alexander. Let's talk about him for a minute. You remember Dr. Alexander. He is a world-renowned expert on child abuse injuries, on rape and sexual abuse of children, and physical abuse of children. He's board certified in child abuse pediatrics. He's been a practicing pediatrician for over 35 years. He was the director of the state of Florida Child Protection Team, still works with them, where he works out of Jacksonville with the University of Florida. He is a professor of child abuse pediatrics to doctors who have gone through their residency and are pursuing fellowships and board certification in child abuse pediatrics. He has lectured on the issue. He has published on it in peer-reviewed articles that have been cited. He is a world-renowned expert, probably the most foremost expert in the United States on this issue. He came to this courtroom last week and he testified to you that the injuries to Felicia, to her vagina, to the area of the fourchette, to the bottom of her vagina, were caused by blunt impact from either a penis or an object shaped like a penis, like a dildo or a sex toy. These injuries. He told us that, and you can see the injury there and here. He told us, and that states a KB32, and this is KA1. Those are the two injuries. And right above that, he told us this is the evidence here of penetration. Her vagina was penetrated by that object. Dr. Downs 100% concurs and agrees with that. Dr. Alexander tells us is this little 9-year-old girl is missing her hymen. It's gone. Her hymen was taken by this defendant. And he said, when the hymen is gone, it is necessarily evidence and proof of penetration. She was penetrated. There is trauma here. And you remember the testimony of another scientist who follows the scientific method, who does analysis and experiments. Charlene, it's Forrester, is it Webster? Charlene Webster. We knew her as Forrester. We didn't know she had been married. Miss Webster came in and told you she's a biologist and she's a DNA analyst. The swabbings taken from the vagina tested positive for blood. They tested positive for Felicia's blood. Felicia's DNA was recovered from the blood. Dr. Kurz told us he believes it's likely this was caused by rocks. Dr. Alexander, Dr. Downs disagree. I'll talk about that in a minute, but the basis was he didn't see blood, and there certainly was blood in the area. I'm not faulting Dr. Kurz. Dr. Kurz is a good doctor. He testified to the cause and manner of death. He concurred with Dr. Downs, but he doesn't have anywhere near the experience of Dr. Downs or Dr. Alexander, and he's not board certified in child abuse pediatrics or pediatrics at all. And you may recall he did come in yesterday to defend himself and his integrity and tell you that these injuries here were not caused by cotton swabs. They were caused, he believes, by the rocks, but they were there when he collected or tried to collect for DNA. Dr. Downs concurs with Dr. Alexander. He's a forensic pathologist with over 35 years' experience, including areas in coastal areas where bodies are found frequently in water. He has experience with that. And he pointed out, I think in a very gracious manner, that an inexperienced or someone not with his experience level, a forensic pathologist may have missed the fact that water can diffuse and can wash away blood, and that blood can leak into water. And he's the one that told us something that makes absolute common sense. There's a lot more water surrounding the body than there is blood within the body. So it's going to diffuse into the water. And that's what happened in this case, in his opinion. He also believes these are penetrating blunt impact tears to the victim's fourchette and hymen, vagina. We know Felicia was in the bay for at least 15 hours, if you go from midnight to 3 o'clock the next day, and she was actually found after 3 o'clock. All of that evidence makes complete common sense and makes sense based on this scientific and credible expert testimony. Another thing that Dr. Downs pointed out Dr. Downs talked to us about why he knows for a fact that these injuries to her vagina were not caused by the rocks. The first thing he talks about is the location, the remote location of where the injuries were found. And he points out to us, as suggested examples, states K56, Felicia's neck, states K18, Felicia's right armpit, states K3, Felicia's navel. How there are areas that are anatomically protected and there is an absence of the incised abrasions and the incised wounds or post-mortem artifact to her body. This, he said, was very suggestive of, or very demonstrative of what he's saying, because the navel was only about 1/4 of an inch deep, but yet going across there, there's injuries around the rim of it, there's injuries across it, up here, but nothing inside of the navel. Just like there was no injuries on her neck and under her arms. States K48, because they're in a protected, remote, isolated area of the body. And then this photograph of Felicia's groin area, which, if you recall, tried to talk to Dr. Anderson about, and he wasn't having any of it. He wanted to keep talking about his opinion, not answering my questions. This area here, where there's not any injuries, there's area here where there's mostly no injuries, there's one here, and there's this one here. Other than that, there's no injuries in this area here near her vagina, because our common sense tells us a woman's and a little girl's vagina is protected up between their legs. And it would have been protected from these rocks which as her body was going on the rocks was scraping across the top of her body, the front of her body, not into the crevices of her body. And Dr. Downs even pointed out that Felicia's pigment in her skin, by her nose and by her eyes, where there were sockets and little crevices, was still present, whereas on her stomach, her skin and the pigment had been debraded and taken off. He said this is a mechanical protection that extends even further in this area because of the labia, the external lips of the vagina that close and protect the internal genitalia of a woman and a little girl. And we saw in the photographs, again, that I tried to talk to Dr. Downs or Dr. Anderson about yesterday, where to even reflect and show, this is KB31, her vagina and its entrance and the injuries, the doctor had to reflect the labia and the skin away. So this is not only a remote area, it's a protected, anatomically protected area, which he would not expect to see these injuries in. And in fact, you don't see them in that area. There's no injuries anywhere near this injury. It sits in isolation by itself for inches in all directions with no other injuries, which told him and told Dr. Alexander that that didn't come from the rocks. And he tells us, Dr. Downs does, that they don't have the same appearance as the other injuries or damage to her body. He tells us, first of all, these were caused pre-mortem and anti-mortem, meaning before death and during death, during the attack. He tells us these are blunt impact tears. But they don't have the same design, they don't have the same type of pattern as the scraping and the abrasions on the top of her body. They are deeper than they're longer, whereas the other ones are not, and they don't have the same appearance. He also told us that if a rock or rocks had got in there to do that somehow during the process of all the time she was floating up against those rocks, he told us you would have expected to see some injuries around it somewhere. Somewhere. Common sense tells us that's true. Dr. Downs interestingly talked to us about Dr. Joe Davis and his statements about the scene and death investigations, that it hinges on the scene, he told us. Investigations of death. It's not just the injuries. You look at the circumstances the body was found in. He looked at all the circumstances, and he told us based on his experience, looking at the totality of the circumstances in a universal way, which is the way a forensic pathologist should look at the circumstances surrounding death. That this has a sexual component, not just the suggestiveness of the injuries and the penetration, but the circumstances. She's deposited in water, which is suggestive of a sexual battery or a sexual component because of getting rid of evidence. And the DNA analyst told us salt water and water would wash away all the DNA evidence. Semen, any blood from the offender, although we wouldn't expect any in this attack. Skin cells, it would all be washed away by that kind of exposure to salt water and that length of time. And you saw the activity of her body in the water, how she was being pushed back and forth with the water going back and forth across her body. Now, just let me talk about it because I may forget. Counsel talked about there was no evidence of a struggle in the apartment and there was no evidence of any DNA in the apartment. So let's talk about this. This little girl wasn't hacked to death or stabbed to death. These weren't bloody injuries. There was very minute amount of blood associated with these injuries to her vagina. She was strangled to death, which doesn't open up her neck. There was no evidence of any kind of injury to her neck where she would have bled. There was no lacerations. There was no incised wounds to any of her arteries. Could there have been skin cells on carpeting in an apartment that vast of a size? Yes, there may have been. But Terry DeWitt can't go in there and do the entire carpeting in the entire house to look for it. And whether it would even be there is a whole other issue. This isn't the kind of crime that would be suggestive of leaving deposits of DNA in that apartment. That's number one. As far as a disturbance, I would only ask you to look at the photographs. What is there to be disturbed in that apartment? What is there to be disturbed? There's barely any furniture in that apartment. There's barely anything to be disturbed. The things that were disturbed in that apartment were in the guest bedroom where the defendant's belongings were. And you remember the testimony of Carlos Lopez and the testimony of Detective Carroll when he went in, when they did that search warrant early in the morning of the 12th? They found clothes that were strewn on the ground in a pile, most of them folded, but they were kind of in a pattern that where someone had not folded them together, but they had been previously folded. Both of them said it was suggestive that someone had picked up a suitcase and dumped it out or emptied it out. That was the only sign of any kind of a disturbance, which would have been when this defendant emptied out his suitcase to make room for Felicia's corpse. This isn't the kind of case where you're going to have massive amounts of DNA inside of the crime scene. It's a little girl who's strangled to death, not stabbed to death, not beaten to death. She was beaten, though, but not to the point where there were open lacerations on her body from the beating. All of that was internal bleeding, internal within her skin. But he tells us when a body's placed in water, Dr. Downs, that there's a sexual component to it possibly. When it's a female, it's even more suggestive of a sexual component because females are victims of a specific crime called rape. Men are rarely ever raped, ever. Females are, for the majority, we heard through the testimony, Dr. Kurz told us when I asked him, would you expect a 23-year-old woman or have you ever seen this in your experience raping a 9-year-old girl? He said no. No. And our common sense tells us that. 23-year-old women don't rape 9-year-old girls. 35-year-old men do, occasionally. On top of being placed in water and being nude, or being a woman, her body was nude. And I talked about that in the opening, and you saw that. Let's talk about that. We know she was wearing a pair of jeans. And that's extremely significant. She's wearing jeans. She's not wearing leggings. She's not wearing little shorts. She's not wearing a skirt. She's not wearing a dress. She's wearing jeans that fit tight to the legs, and they're made out of a rough fabric, denim. She was wearing shoes. She was possibly wearing panties underneath her jeans. We don't know that for a fact, but hopefully. A shirt, a black shirt with green stripes. Interestingly, which the defendant describes to the detectives after telling him, I don't remember what she was wearing. When they push him, he does remember what she was wearing and has a pretty good memory of it. Striped shirt, jeans, and black shoes, which is exactly what she was wearing. When she's found in the body, there's not a stitch of clothing on this little girl's body, not a thread. Nothing is found on her body. And we know the rocks didn't do that, because half of her body's not even affected by the rocks. Her back is not even affected. We know jeans aren't going to be torn off of her body by rocks. So why is she nude? Why else would she be nude if she wasn't raped? Why else would she be nude if this wasn't a sexually motivated homicide? That makes no sense whatsoever. I'm going to strangle a little girl for no apparent motive or reason, not sexual, and then I'm going to strip her body and throw it in the bay. That doesn't make any sense whatsoever. As I said in my opening statements, why else would a 35-year-old man kill a little girl? And why is her clothing gone? Clothing that we have never seen since. And you heard about the extensive searches up and down the Courtney Campbell, all over Temple Terrace, all over near the apartment complex, into retention ponds, storage areas, donation boxes for clothes. Nothing was left unturned in this case, and those clothes were never found. The clothing that the defendant had a very particular memory of. This little girl was found in the water without her clothes on because she was raped. And that's what the evidence shows us. It's not just this scientific evidence, medical evidence that tells us that. It's the circumstances that tell us that beyond any doubt, that this was a sexual crime, that this little girl was raped. But we know from the evidence, Felicia wasn't the only one with her clothes off in this case, right? Because when Ebony Wiley came back from the CVS, the defendant, when she got to the door, didn't have his shirt on. Remember that evidence? More evidence of sexual battery. Why is his shirt off? Calissa Kelly tells us he left that morning with a white shirt with a pocket on it, with some kind of a manufacturer label on it, like Izod or Polo, I think she said, maybe Ralph Lauren or something. But that shirt is off of his body when Ebony Wiley gets there, and he's sweating, and he's panicking, and he's upset. And Felicia's body is nowhere to be seen, although Ebony doesn't search the apartment. She trusts my husband. Why is his shirt off? It's off because he was raping her, because he had his clothes off and he had her clothes off. Because he was violating this little third grade 9-year-old. And then finally we come back to the 911 call. Something made Felicia very, very afraid, terrified, enough to pick up the phone and call 911. He was doing something to her that made her uncomfortable, that made her afraid, something to where she reached out for help. And then in the defendant's statement, of all places, we find evidence that this was a rape. Because about halfway through that statement, out of the blue, without any suggestions being made to him, the detectives haven't said a word about how Felicia was killed or whether or not there was any sexual issue in this case or sexual component to this crime, because they don't know. They know there's been a body recovered about halfway through the interview. They know that. They don't bring it up. They've been told it's her, then they've been told it's not her, then they were told it looks like it probably is her. And we know from the evidence, Detective Elmer and Detective Smith were over there looking at the photos and bringing them back to Temple Terrace, the photographs that were collected from the scene, the pictures of the body of Felicia when she was moved out of the water. But without any urging, without any suggestion, the defendant tells him, you know, when they kept talking to him about this little girl's missing and we need to make sure she's okay, in Jamaica, when someone molests a child, he brings up the word molestation, he doesn't say they go to jail, he doesn't say, he says we take care of them, but then he says we throw them in. Making another reference to a fact in this case, that her body was thrown into the bay. And he's using that reference to describe what happens to people who molest children. Out of the blue, the defendant inserts this sexual component to what happened to this little girl. That evidence, combined with all the other evidence that we've just talked about, proves to you, beyond a doubt, and it is crystal clear, that he raped this little girl. Nobody wants to think about this. Nobody wants to dwell on how this happened in the actual scenario itself. It's not a pleasant thing to think about. But you have to think about that in this case. And then, you can't get out of this recording without this defendant who has already made suggestions about this little girl being a bad kid, having all these issues. The defendant sexualizes this little 9-year-old kid. He says to the detectives, she was out giving head. He describes and attributes something to her that may be attributed to a grown woman, a description of promiscuity of a grown woman. He attributes that, and sexualizes this little girl. Why is he doing that in this interview? Why is he saying that to these detectives, that this little girl's out giving head? Because maybe in the back of his head he's trying to justify what he did to her. What other reason would he have for bringing that up if this wasn't a rape and a sexual assault? Now, there is no evidence in this case about what happened to this little girl. She was raped and she was strangled to death. I guess I need to talk about Dr. Anderson for a minute, because he gives us this compressive asphyxia nonsense. You'll be given an instruction. It was read to you, I believe, yesterday. You can consider the testimony of a witness. You can accept portions of it. You can reject portions of it. You can find some of it reliable or credible and other portions of it not reliable. But one of the instructions, which makes sense, is you're to look to the witness, not just what they tell you, but their demeanor and how they act on the stand. Were they forthcoming in answering the attorney's questions? Dr. Anderson was more than willing to answer this attorney's questions, the defense counsel's questions. More than happy to answer his questions in a responsive way that made sense. But when I got up and started questioning him about the circumstances of the crime, about the nature of the wounds to the neck and to the internal structures of Felicia's neck and how they're up high up, he insisted on making speeches. He insisted on arguing with me. How many times did I have to say to him and ask him, did I ask you that? Is that what I asked you? And then at some point, he just made speeches and just kept telling you, trying to wrap everything back up into this theory of his, that this is apparently the third time out of 9,000 autopsies that he has seen asphyxia, compressive asphyxia, in a homicide case. This extremely rare event that he's going to reach out for because she has bruises on her shoulders, which Dr. Downs and Dr. Kurz tell us as forensic pathologists were most likely caused by someone grabbing her shoulders or slamming her on the ground by her shoulders or having her on her back and laying down over her, pushing her shoulders into the ground to pin this little 9-year-old kid while they shove their penis into her body. This doctor is taking this and ignoring what's obvious and trying to center on the most non-obvious things in the case itself. And on top of all of that, he can't get off the stand without making this outrageous allegation against Dr. Kurz, that Dr. Kurz caused these injuries with a cotton swab, and that Dr. Kurz came in here and testified under oath to something different. And then he gives him an out, well, maybe he missed it. Well, those are pretty obvious injuries. You're not going to miss those. So we had to bring Dr. Kurz back over here in rebuttal, and he was willing to come over from Clearwater, from his job. He came in here in his scrubs, and he set the record straight that that was a bald-faced lie. And you remember the progression of this unbiased scientist, as he described himself, as he tried to bolster himself in front of you after it had been revealed through my voir dire of his expertise that he failed his clinical board certification examination the first time he took it. We never would have heard that if I hadn't asked him. Dr. Kurz comes in and defends himself and says, no, the injuries were there when I collected or attempted to collect DNA evidence, which we did get DNA evidence from her vagina. We got our own blood from her vagina. There was overwhelming evidence in this case that she was sexually battered. Now, I want to talk to you about first-degree murder and premeditation. You heard the instruction yesterday on murder in the first degree. It can be proven one of two ways, and you probably remembered this from jury selection. Ms. Johnson talked about this. First-degree murder can be proven by premeditated murder or by felony murder. So I want to talk to you first of all about first-degree premeditated murder. And this is the instruction that you had in front of you yesterday. We have to prove that Felicia's dead, and we did that beyond a doubt. We have to prove her death was caused by the criminal act of Granville Ritchie, and we did that beyond any doubt. And then we have to prove it was premeditated. Now, to be premeditated, we talked about this in jury selection. What we don't have to prove to you is that this was some kind of ongoing plan that had been planned out for days or even hours or even minutes. Premeditation can occur in a matter of seconds as long as there is enough time for the person to reflect, that is, to consider and decide what they're going to do before they do it, and not act just immediately, but to have some decision making, and that can occur in seconds. So premeditation is killing. After consciously deciding to do so, the decision, I apologize for moving this, must be present in the mind at the time of the killing, so he must have an intent to kill at the time he kills. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing itself. It must be long enough to allow reflection by the defendant. Reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. So even this is echoing Dr. Downs. You look at the circumstances. You look at this in the totality. You look at all of the things he did, the way in which Felicia died, the types of injuries she had, the things that occurred leading up to the murder, the things that occurred during the murder and after the murder. Those are the things you look to decide whether her death was premeditated. This murder was a premeditated, orchestrated plan of manipulation. We know that from the evidence. It was an orchestrated, manipulative event. To get to this little girl, the defendant first had to go get her. He had to set it up to bring him to the apartment, and then he had to get Ebony Wiley out of the way and get her away so he could have access to that little kid. He was supposed to be in St. Pete that day with Calissa Kelly, but we know from the phone communications, you can see it in his records, and we know it from the testimony of Ebony Wiley that they were communicating. She called him, told him she was getting off work, and they decided together to go pick up Felicia. He told the police in his statement, and Ebony told us in her testimony, corroborating each other on this issue. Ebony had had some issues with Felicia walking up to her work. I want to get off on another tangent, but I want to talk real quick about that. This supposed animosity that would have led Ebony Wiley to murder Felicia. What we found ultimately in the very end through the testimony of Detective Kelly was that, yes, Ebony Wiley allegedly, through the testimony or through the statements of Jeremicia Williams, her older sister, who was 11 years old at the time, talking to a detective the day after her sister went missing, that she and her sister were walking home, and Ebony was in a car that drove by, and Ebony yelled at them, they were walking in the rain, to go home, to get home. Does that sound like motive to commit murder to you? Because it was represented to you by the defense as being motive to murder this little girl, to strangle her to death. This defendant suggested to Ebony Wiley, I can help you with that. Remember he told the police, I told her I could help her with that. No, the little girl's reaching out to you. She's reaching out to you, and we can see the manipulation oozing out of that video when he's telling the police that. And we can see it through Ebony's testimony. I can help you counsel her. Let's go get her. He tells Ebony, we'll go to McDonald's. That's what Ebony tells us. We'll go to McDonald's and sit down with her. Ebony thinks they're going to pick up Felicia down in Tampa, and they're going to go to the nearby McDonald's. But instead, as soon as they pick up this little girl, as soon as she trots out and so happily jumps into the back seat of that car she's never been in before, they take off towards Temple Terrace. This defendant's heading back to the apartment because he's got one thing in his mind at that time, the evidence shows us in this case, and one thing only, and that's Felicia. Not Ebony, Felicia. They drive immediately back up to Temple Terrace, and Ebony told us that wasn't what the plan was. We were supposed to go to McDonald's. And then he starts suggesting we can just have food my mom made. She ain't going to eat that food. She's not going to eat that food. Okay, because apparently Felicia told them she'd only had a bag of chips that day. So they drive up into Temple Terrace, and he suggests they go to Checkers. In his statement to the police, he says, she wanted Checkers. Well, he suggested it, according to Ebony Wiley. So they go to Checkers. We know that happened. There's no issue about them going to Checkers. That's been proven to you. And the last meal that Felicia gets to enjoy in her short little 9 years on this earth is some shrimp, maybe some fries, and a Sprite. That's her last meal. So they pick that up, that box of food, and he takes them immediately back to 8910 Tanglewood, apartment 721. Before they're even out of the car, he is slipping Ebony Molly, a drug that he has seen her on before, that he knows how she reacts to, a drug that he has seen her under the influence of just a couple days before. So he hands her this drug, she takes it, and he knows it'll make her more easily persuaded and manipulated. Why else would he give her that? And they go up into the apartment with this little girl, and he tells us, and Ebony tells us, they go through this little charade he does of talking to her about stealing and put some money out. And Felicia tells him, I don't know, maybe, it might be gone, I don't know. But not too long after that, and we know this from the evidence, it's fairly fast how quickly this happens. In fact, let me see if I can go through this with you. Is it auxiliary? Auxiliary? Okay. Okay. So there they are driving north on 56th Street at 3:47:44. And this will also show you how reliable these red light camera photographs are. That's 3:47:44 p.m. Felicia's in the back seat. Ebony's in the front passenger seat. Felicia's sitting behind the front passenger seat in this car. Remember? She hopped in behind the front passenger seat. Well, I'll come back to that in a few minutes when we're talking about suitcases. The Checkers receipt is at 3:49 p.m. So 3:47:44, about a minute later, they're at Checkers. We know that they're at the intersection right there, River Hills and 56, just south of where the Checkers is. Then we know at 3:54, just a couple minutes later, the defendant twice mistakenly puts in the wrong number, and then finally gets the 2222, Gloria Gibson's name, and they enter into the apartment. At 4:41, so that's 3:54, 4:41 to 4:45, what is that, 45 minutes later? 45 minutes later. It doesn't take this defendant very long. He's already asked Felicia to try to find some weed for him. And these phone calls, she's calling her granddaddy, Nathan Teal, who was the older gentleman who came in here and told you he is Ebony, not Felicia, Ebony's granddaddy. And she called him, and you remember the testimony from Corporal Staley, now Captain Staley, and Detective Tom Carroll, who's now retired, that they went out and interviewed Mr. Teal, her grandfather, Ebony's grandfather, and he said, yeah, she called me, and yeah, here it is on my phone, and shows it to him. This is from from Ebony Wiley's phone, the download done by Connie Bell in the digital forensics section of the Florida Department of Law Enforcement. So she starts calling him at 16:41. So between 4:41 and 4:45, they're having conversations, and you see the incoming call, 4 down. That's her grandfather calling her back and telling her, and you can see the length of the call. It comes in at 44 minutes and goes to 35 seconds. He's telling her, I found someone who has some dope, some weed, Mo has some, and there she is leaving at 4:51. So 4:45, 6 minutes later, there's the Lexus going across River Hills, westbound into the city of Tampa. There's the proof that she goes to buy marijuana, the first set of proof, in addition to what Nathan Teal tells you, in addition to what Valdemar Vernon comes in here and tells you, the young man who had the pleasure of coming in here and telling you that he sold her marijuana. So she's heading at 4:51. 45, a little less than an hour that they've got there. And this defendant has already manipulated this woman, and she tells us when she got up off the couch, she was feeling the effects of the Molly. He's already manipulated her and persuaded her, and of course she left to go do this at his persuasion. because he's also pulling at her heartstrings. She thinks she's going to end up marrying this man. And she told you, he sold me a dream. Remember her testimony? And in fact, if you don't want to believe her, just listen to the defendant's statements as he brags about how he manipulated her and Calissa Kelly and how he treats them and what he thinks about them when he's talking to the police. How Calissa Kelly is 40, older than him, can't tell her anything. She never listens to me. Ebony, she's 23. I can work with her. That's the way he describes it. I can work with her. I'm sure he can. 5:26. Now, she's left at 4:51, so she probably left at 4:50. It takes about a minute and a half probably to go south out of the apartment complex onto River Hills and go west. So about 35 minutes later, she's coming back. That's her in the turn lane to go eastbound on River Hills towards the apartment complex. Which we know she can't get in, and she talks to the defendant who tells her, I gave her some candy, and I told her she was going to CVS to get some candy. So she says, I think I'll go up to CVS. She tells us, I think I'll go up to CVS. Well, really? Is that what the clerk who worked at CVS told us, that this was just some casual her walking in looking for Felicia? No. She came in there, according to Miss Rivers, the young lady who testified from CVS, literally in tears and broke down in tears on the way out. She knew she had screwed up royally. This little girl, something had happened, and she knew it. So 5:39, Detective Carroll tells us on the video she goes through this intersection and quickly turns into the CVS. So we know 5:40 approximately she's at CVS. That's her in the upper left corner of the photo above Miss Rivers' head, in the same dress we saw her come through in the video, and I'm not showing that just for time's sake. There she is in the Lexus, one person driving the car, it's her. And then at 5:55, she tries to put in 3 times the 222 code, which we know is the residential number for the Purdue family. That's why that comes up. And she can't get in, and some little boy with a karate outfit lets her in, who knows the code. So 5:55, around 6 o'clock, she gets back. We know a little bit later she contacts Cha-Cha, Charlicia, and lets her know, your sister hasn't come back yet. But we know now she's getting there at 5:55. She's been gone for over an hour. And now we're about roughly 49 minutes after the 911 call, where we know Felicia was still alive, but extremely terrified by something, enough to call 911. So by this point, Felicia has been strangled, raped, and stuffed either in the suitcase or somewhere in that apartment, hidden, whether it's out on the balcony or the wheel to the suitcase was found and all the scuff marks, or in the guest bedroom that Ebony told us the defendant wouldn't let her go in, where the suitcases were. So he's been with this little girl alone for an hour. Last person to be seen with her alive. At 9:03, this is the Lexus coming back from East Tampa, where the defendant went to drop Ebony Wiley off in East Tampa. This is him approaching, again, River Hills. His car is covering the turn arrow. But he has dropped her off, and Miss Wiley said it was sometime after 8:30. That corroborates her testimony. All of this evidence corroborates her testimony. All of this evidence shows she never had opportunity to commit a murder on this little girl. She certainly didn't have access to a car. There's no evidence in this case that she ever had access or ever drove a car. She was in a car when she saw the kids and yelled at them to get out of the rain and go home. The only person with a car in this case is the defendant. So at 9:03, he's returning now, heading northbound and turning into the west or eastbound River Hills, going back towards Doral Oaks. And then at 9:03, there he is putting the gate code in. This evidence dovetails, it matches, it corroborates like the scientific evidence does. And when evidence does that, when it corroborates each other, all of this corroborates Ebony Wiley's testimony to you, that she went to buy marijuana, that she came back, that she went to the CVS, that she came back, that they stayed in the apartment. The defendant tells the detectives, because they keep pushing him on it, so what did you do to try to find this kid? oh, I walked out on the balcony and I looked hard. I looked from my door and I looked around. And then when I went to Thanodisassa, I came back and I went out and I looked. Maybe she was knocking on somebody else's door. Okay. Does that sound reasonable? A grown man who a child has now gone missing, that he's not going to start tearing apart the apartment complex? He had any half decency? So, 903, we know he's back at the apartment. We know he never goes anywhere east of that 124 Bullard Parkway cell tower across the street. We know that from the records, from the cell phone historical analysis done by Agent Justin Fleck. So going to Thanodisassa is another lie that he tells to the detectives. He's there at the house, and he's there till at least 10:36 when his cell phone is pinging off that 124 tower, 124 Bullard Parkway, the same tower that Tiffany Morse came out to looking for the 911 caller. But we know he's there for an hour and a half at least. For an hour and a half at least, he's in that apartment, figuring out what to do with Felicia's body, where to take it. We know that he waits. Now, remember, he's returning at 9:03. This is, again, from Ebony's download of her phone. This shows at 9:13, she's calling Kenny Shelton, her brother. And 9:16, she's calling Cha-Cha Baby, who is Charlicia Adams, the older sister of Felicia Williams. More corroboration. This is just after 9 o'clock she's calling them. And we know why she's calling them. She's telling Cha-Cha to meet her at Lake and 22nd, where Mr. Shelton says he finds both of them on foot walking. Because, again, Ebony Wiley doesn't have access to a motor vehicle. This is that cell tower. Right to the left in the photograph of the red shading is the intersection of of 56th Street and Bullard Bush. This shows a call, you can't see it from there, of 10:36 and 30. 10:36 and 30, that's the last call the defendant makes. And the entire time he is here, from 4:07:59 p.m. to 10:36 and 30 p.m., so for 6.5 hours, his cell phone is pinging off of that tower in that southwestern sector of the tower, which is right where that yellow dot is, where the Doral Oaks apartments are. (10:51:01). There's the Lexus. It's going westbound, the same direction that Miss Wiley went to buy the marijuana, except for she went westbound through the intersection. He's turning southbound onto 56th Street, going into the city of Tampa. And then we know from the cell phone towers, the upper right-hand corner is the 124 Bullard Tower, where he's hitting off of at 10:36. And then he goes west, southwest, through the city of Tampa, down across to that far left corner of that slide to that cell tower just south of the airport, and he's in the northern sector facing up, which is north, heading towards the Courtney Campbell Causeway. As I said earlier, this was an orchestrated event to get his hands on Felicia. This took place not only over the course of seconds or minutes, probably over the course of an hour or more, that this defendant had in his mind that he was going to sexually batter and murder this little girl. And we know he had to be considering murdering her, because he did murder her, because he didn't want to leave her there to tell anybody what he did to her when they were all alone, just the two of them. He manipulated Miss Wiley to get her out of the way, this whole charade of wanting marijuana, to get her to leave. And you remember, she starts to leave, and she looks at Felicia, come on, baby, let's go. Felicia hops up, and he, oh, no, baby, you can't do that. No, you don't have a license. You're going to buy marijuana. You can't take a little girl with you. And he convinces her, and it didn't take a lot of convincing. She's under the influence of drugs. She is head over heels in love with this guy. After he murders Felicia, he doesn't just tug at her heartstrings, like I said earlier. He starts appealing to her own self-interest. You can't tell them You can't tell them that I was here. You can't get me involved. You'll look horrible. If this family knows that you brought that girl around a man, you'll look horrible. And he starts the orchestration and the deceptive manipulation that leads to the lie that gives him the time to go to deposit her body out in the bay and to evade law enforcement for half a day, more than half a day. That evidence tells you how premeditated this murder is. But we know there's a lot more to this case than just that evidence as far as premeditation. We know from Dr. Downs, it takes effort to strangle somebody to death. It takes a lot of effort. Even to kill a child, it takes effort to kill another human being with your bare hands. She wasn't stabbed, she wasn't shot, she wasn't poisoned. She was strangled to death, up close and personal. We know Felicia didn't just suffer one injury to her neck. We know she suffered multiple injuries to the internal structures of her neck, up into the high portions of the internal structures. Dr. Downs tells us more injuries than he maybe has ever seen in a strangulation case to the internal structures of the neck, all the strap muscles. We know from his testimony that not only are there multiple injuries to the internal structures of her neck, that they're way inside of her neck, down below the layers, multiple layers of strap muscles down to the longest muscle that Dr. Anderson didn't seem to understand what I was talking about, that run next to the spine behind the trachea. And he told us to get down to those and cause injury to those requires a tremendous pounds of force and power to be exerted on this little girl's neck by this man. That alone takes deliberate, thoughtful action to place your hands on one of the most lethal portions of the human body, one of the most fragile portions of the human body. He targeted her neck with his hands, and he squeezed hard, and that took deliberate, thoughtful, continuous action. Now, we know that this isn't like a movie or TV where you strangle somebody for a couple of minutes and they die. We know from Dr. Downs that as long as the carotid artery, which is supplying oxygenated blood to the brain, as long as that is occluded or cut off, the person will at some point, if it's continuous, both sides of the neck, both carotid arteries are cut off, the person will at some point lose consciousness. If it's continuous, 10 seconds at the bottom, maybe more, maybe up to a minute, to lose consciousness. But that has to be consistent. And a lot of times that's difficult, even with a child pulling and moving around and wiggling, because this is going to hurt. And she is going to try to get away from it, and she's going to try to move. Felicia Williams, as a 9-year-old, was not some little wallflower. She was 120 pounds, 4'9" or 10. She was a big 9-year-old. And she struggled and fought. That could have caused that process to loss of consciousness to take minutes, where he had to continue to squeeze and be deliberate and fight with her and get her hands off of his hands and her nails off of his hands. At some point when she did lose consciousness, it doesn't stop there, because the person can come back. If you let go, the oxygenated blood resumes back to the brain, and the person will eventually revive and wake up. To cause death, once consciousness is lost from that blockage, the person has to continue to occlude both carotid arteries. They have to continue to strangle this unconscious person who would be laying there, unconscious, not moving, not doing anything, just laying there. They'd have to continue to do that for at least minutes. And the reason for that was explained to us by Dr. Downs, because there will always be residual oxygenated blood in the brain that have oxygen molecules in it. The brain will exhaust that oxygen. It'll work through all of that that's already in there, and that'll take minutes. That's assuming that the person doesn't let go. That's assuming that the person who's strangling, looking at the person being unconscious, after a minute says, oh, they're probably dead, and let's go, and then they'll wake up again. So we don't know how many times that happened. This could have been a long, long time. But we do know it's at least minutes of pressure being exerted on this unconscious body of this little girl by the defendant. Minutes at least. So really, when we think about that and try to conceptualize that, he's alone in this apartment with this little girl who's now unconscious, and he's squeezing her neck. He's compressing her neck, waiting for her to die. So to conceptualize that time, let's just take 1 minute. Let's just take 1 minute. All of that time, he would be squeezing her neck, compressing her carotid artery on both sides, and that would have to take that amount of time and then another minute or more for him to cause death. Think about how deliberate and thoughtful that is. Think about how much thought and reflection that would require, because during that process, he's going to be feeling her pulse popping up underneath his hand where the blood's trying to get through. He's going to be feeling the heat of her body. He's going to be looking at this little girl's face. And at every second of those minutes, as she lays there unconscious, this little girl, is a second that this defendant could have stopped. It's a second that he could have used mercy. He could have allowed her to live. In every one of those seconds, he had to make the decision to continue to do what he was doing, to continue to pursue her death. This is not just a premeditated murder. This is a highly premeditated murder. That evidence alone, just the strangulation, is overwhelming evidence of premeditation. But we know the premeditation stretches back over an hour, probably all the way over to Pinellas County to St. Pete, when this took formation in his mind. And then we know the defendant would have to move quickly because Ebony was coming back. Ebony said she called to check, and that's in the phone records. You'll see it in his phone records. She did call. During that time period, she was gone. So he knew she was coming back. So, again, more charade, more deception. Go to CVS to keep her out of the apartment so he can hide Felicia's body, stuff it wherever he put it. Maybe it was in the suitcase at that point. Maybe not. Maybe not. Felony murder, first degree. Felony murder is the commission of a murder or a killing while engaged in the commission or attempted commission of a sexual battery where the victim was less than 12, the defendant over 18, or an aggravated child abuse where Granville Ritchie caused her death and he was the person who actually killed her. And it's not necessary that we prove premeditated design or intent to kill. Now, all we have to prove is that he attempted to kill her, and we know he did kill her. And we know this happened during the commission of a rape, capital sexual battery of a child under 12, and we know it did happen during child abuse. So he is clearly guilty of both types of murder, and they can exist co-equally and together, coexist together. You will be offered in your verdict to find the defendant guilty of premeditated murder or felony murder, or both premeditated and felony murder. And I would strongly suggest to you that the evidence has proven both forms of first-degree murder beyond any doubt. I want to talk real briefly about the lesser-included offenses, but I do want to talk to you about, we talked about sexual battery. I think I may have misplaced my child abuse instruction. Is that over there? Is that right there? Aggravated child abuse. Aggravated child abuse is the defendant knowingly or willfully committing child abuse upon Felicia. In doing so, he caused great bodily harm, permanent disability, or permanent disfigurement. Well, he murdered her, he killed her. So yeah, he's permanently disfigured her and disabled her, and she was under the age of 18. Child abuse means the intentional infliction of physical or mental injury upon a child, or an intentional act that could reasonably expect it to result in physical or mental injury. And I would suggest to you that the evidence in this case has proven that he committed both physical and mental injury to this little girl, as evidenced by not only strangulation, but the rape and that 911 call showing what she was going through in her mind mentally. There are some lesser included crimes. I'm only going to talk about two of them, the first-degree murder. One is murder in the second degree. Murder in the second degree, we have to prove that Miss Williams is dead. Her death was caused by the criminal act of Granville Ritchie, and there was an unlawful killing of Felicia Williams by an act that is imminently dangerous to another, demonstrating a depraved mind without regard for human life. Well, have we proven that? Sure we have. It was eminently dangerous to strangle her and demonstrated a depraved mind without regard for human life. But this doesn't require that we prove premeditation, and we did prove premeditation, and that's how and why we've proven first-degree murder. Eminently dangerous and demonstrating a depraved mind means a person of ordinary judgment would know acts that are reasonably certain to kill or cause serious bodily injury is done from ill will, hatred, spite, or an evil intent. Clearly, this was done from an evil intent and is of such a nature that it indicates an indifference to human life. And as it says here, it's not necessary for the state to prove the defendant had an intent to cause death, but clearly we have proven that. You will hear an instruction, and I'm just going to paraphrase it from the court, that when you're looking at these charges, when you go back to deliberate, after selecting your foreperson and beginning your deliberations, you're to look to the charged crimes first. If you find we've proven all the elements in the charged crimes, you should select guilty and your analysis should stop. Consideration of lessers is only if you find we have not proven beyond a reasonable doubt all the elements of first-degree premeditated murder and first-degree felony murder. Now, with felony murder, there is an instruction called inseparably intertwined crimes. Because felony murder, first-degree felony murder, requires that we prove the underlying crime of rape or child abuse to you beyond a reasonable doubt. Now, if you find that we have proven that he raped her, and you find that we've proven that he committed child abuse, that doesn't allow you to automatically say he committed felony murder. You still have to find the elements of felony murder, which are that he killed her in the commission of those felonies, which clearly the evidence has shown. I just say that to you because you will receive an instruction called inseparably intertwined crimes. You saw it yesterday, and it just means that those crimes are intertwined to the extent we have to first of all prove the underlying felonies for you to find him guilty of felony murder. Ebony Wiley, I believe I've talked about a lot of this, but I just wanted to talk real briefly about it. 23-year-old women don't rape 9-year-olds. and they don't murder 9-year-olds based on a sexual motive. That just doesn't happen in the real world. The evidence in this case doesn't support it. There's no evidence she had any kind of motivation to murder this little girl. They did things where it demonstrated she felt very lovingly towards this kid. They did nice things together. Did she let that little girl down? You bet she did. You bet she did. She let her entire community down that day when she left this little girl with this man she had just met. She made a foolish decision, but this is a 23-year-old woman that was being manipulated by a 35-year-old man. I'm not trying to excuse what she did. She lied to the police, and she allowed him to escape the police. She allowed him to make it to the Courtney Campbell Causeway and dump this little kid's body in the water. She was charged. She was charged with making a false statement to law enforcement during the course of an investigation of a missing child. A charge that's still pending against her. She is paying, and she will pay. She will pay for what she did, for her role in this. But did she murder this child? Is there any evidence in this case to suggest that? No. There is no evidence to suggest that. There is no evidence in this case that suggests that anybody murdered this child except for this defendant. Every piece of evidence in this case points to his guilt and points directly at him. Every single piece. There's not one iota. There's not one sliver. There's not one particle of evidence that points in any other direction than directly at that table and at that defendant as being responsible for what happened to Felicia Williams. As I said earlier, this defendant would have been screaming it from the roof of the Temple Terrace Police Department during that interview if he thought that she had anything to do with this, and he could get the spotlight off of him. I want to talk to you just briefly. If I can go back to my PowerPoint. Talked about this earlier, the mangrove. I put that in there just to show you its color, that it was fresh. We know from the evidence that the defendant didn't just come back from the Courtney Campbell Causeway with mangrove stuck in his headlight. He came back with all these scratches down the side of his car. And we know that that would be consistent with him going westbound down that north access road because we saw it in the video. We saw and we heard the scratches occurring to Captain Lowell's car just within the last month from mangroves that were cut back further than they were at the time. We know from the testimony of Sergeant Spaulding from the Clearwater Police Department that when she went to that scene going the opposite direction with her driver's side towards the mangroves, the day after, she got scratches on her car, on her brand new Charger that had been given to her by the police department, and she was upset about it. So this is more corroborative evidence, regardless of what Calissa Kelly wants to tell us, that this defendant was on the Courtney Campbell Causeway within hours of Felicia being missing and 15 hours or so before her body was located on the Courtney Campbell Causeway. We talked about the sand, and we know from the testimony of Dr. Christian Wells and other scientists that his geochemical analysis of that sand matched the sand from that area. We know from Justin Fleck, and I know I talked about this earlier, I just wanted to cover it in a little more detail. That's where the defendant's phone started. That's the last place it was, around 10:36, pinging off of that tower at 124 Bullard. We talked about this slide showing us his path westward through the city. in that direction. And then we know at 11:12, he is below that tower, on the highest tower, facing with the sector facing down on the south side of that tower, on the Courtney Campbell Causeway. And at some point he comes back at 11:25, and he's on the western side of the tower south of the airport, still in the area of the Courtney Campbell Causeway. That 11:12 call, we know he has to be, from the drive test using radio frequency technology, more scientific evidence, he has to be in that zone on the Courtney Campbell Causeway at 11:12 p.m., around 6 hours, a little over 6 hours after Felicia was last seen alive with him. We've seen this previously, showing he had to be in that area of the yellow shading. His phone had to be in that area at 11:25 p.m. And then we know that on that call, his call terminates on a tower north of the Courtney Campbell Causeway, up off of Hillsborough. Agent Fleck, to the benefit of the defendant, indicated that he cannot report on that because of the reliability of handoffs, but that's where it ended, north of the Courtney Campbell, just coincidentally. And then we know at 12:11, the defendant is heading off the Courtney Campbell Tower that's sitting on that hotel that's right on the western edge of Rocky Point on the water. He's in the western sector of that tower. We know that's where it is. And on that photograph on the right shows the western edge of the hotel. And that's a photo taken from the west looking back to the east. And these are the towers that tell us the direction he's heading when he's on that tower. He's heading back towards Tampa, back in the direction he would be coming if he had just deposited her body. And he's utilizing those towers. He's in the southwestern sector of the tower by the airport, and then he's going across the Howard Franklin towards Calissa Kelly's house. And he tells the detectives he gets there between 12 and 12:30. He left at 10:50. It's a 40-minute drive. That doesn't work right. That gives us this whole hour that he's in the area of the Courtney Campbell Causeway. Folks, this evidence can't be cross-examined. It doesn't lie. It can't be impeached. It is what it is. It's scientific evidence. And then we know the next day at 11:25 or 11:26, he's hitting off the tower just to the right, the red dot to the right of that box in the lower left-hand corner, down in St. Pete. We know throughout the day, from 11:25 when he gets up, around the time he gets up to 3:28, all of the tower usage is in St. Pete. He's telling the detectives he's in Williams Road and 301. He tells the detectives he goes to see his wife in Riverview. He tells the detectives he's in Hillsborough, and then he comes all the way back to take Calissa Kelly, or go get Calissa Kelly. And we know that's all a bald-faced lie based on that evidence. Then we know he's hitting off these towers between 3:45 and 4:07 when both he and Calissa Kelly are at the Insta-Loan. So I want to go to that slide real fast just to show you how reliable and accurate these records are. So I'm going to use the actual slides that are in evidence. So again, for reference, this is between 3:45 and 4:07, which is pretty much exactly the time that they're at the Insta-Loan. If you look at the video, what did Ms. Kelly tell us? One of her more truthful moments. Insta-Loan is located on US 19. US 19, US 19. These towers are right on US 19. For the record, that is W13, W14. This is between 4:07, this is after the defendant starts to leave the Insta-Loan, and 4:30 p.m. This is tracking the defendant back towards the Temple Terrace Police Department. But at 4:07 p.m., he is hitting on a tower at 5th Avenue in US 19, right there in Pinellas, right there in St. Pete, right where the video shows that he is. The cell tower evidence and the video are corroborating each other. That shows you the reliability of this evidence, in addition to the reliability of cell phone technology that is demonstrated by the use of it by 911 communications and the fact that Officer Morris got so close to Felicia, so close to her. And then this shows us this slide, the defendant tracking back. And again, this is between 4:07 and 4:37 p.m. back into Tampa. And he's coming across the Howard Franklin. He's coming across, he's hitting in these western sectors as he heads that direction. And then he comes up here and he's in this sector here, which comes out like that, like this. Let me try again. And then at 4:37, Agent Fleck told us he couldn't get sector on this tower, so he put a circle on it. He eventually makes his way to the Temple Terrace Police Department, W15. Doral Oaks Apartments. We heard from the evidence that the Temple Terrace Police Department is up in this area, north of the Doral Oaks off 56. And look at the sector he's in, right there, where the police department is. Solid, scientific, reliable evidence. Evidence that you can stand on, evidence that you can base a verdict on. All of this scientific evidence corroborating, dovetailing. I just want to talk briefly about this. I don't want to spend a lot of time on it. I know I've talked for quite a while. I want to talk to you about Amy McFadden and the Noah report. Amy McFadden took the stand and told us right off the bat that her report is an approximation. It's not an exact science. It's not what it's meant for. It's called a drift analysis. It's an approximation. It's not based on measurements of tides, winds, actual measurements of tides and winds. It's based on forecasted, predicted tides and winds based on computer graphics or computer-generated forecasts. Even though it was done after the fact, she didn't base it on what actually occurred. She said Tampa Bay is a complex water system. That Tampa Bay, that also adds to the approximation of her report. But she was very clear that it is an approximation. She was very clear that it was based on the assumption that Felicia's body had just washed up before it was found. It was based on that assumption that she was floating in the bay. That was what she put in to her program. And we know from the facts in this case that's just not true. The extensive amount of incised damage to the front of Felicia's body indicates she was there for hours and hours and hours, rolling up on those rocks and being debraded, or skin being debraded on those rocks. That's what the evidence shows. She had the wrong weight and the wrong height in her report. It's an approximation anyway, so it wouldn't probably have mattered much at all. But she had the wrong information in her report. Felicia wasn't floating openly in the bay until she was found. She had been there for hours on those rocks. And she told us it is, I believe her testimony was just as likely her body could have been found, and according to what she found, where or deposited where it was found. as opposed to the other part. Now, in her report, she says that's most likely, and I believe she says it's as probable that it was located. But we're talking semantics now. Defense exhibit has this gigantic area that is basically almost the entire area of Old Tampa Bay north of the causeway, including where her body's deposited. We know where her body was deposited. We know that from the evidence. We know the defendant had the scratches on his car. He had the mangrove in his headlamp. We know that Captain Lowell, when he went out there to do the video that we saw, he actually got debris in his headlamp of his car. And the soil analysis matches the soil from where her body was found. There's overwhelming evidence that's where it happened. This no report doesn't mean anything. Its weight is extremely small. We gave that evidence to you because it existed. Because it existed, we put it before you. But it really doesn't tell us anything at all, period. And it wouldn't have mattered if they went back and put in 4'10", 120 pounds, even though it was off by a fifth of her weight. It wouldn't have mattered. I'll work through my slides. There was no evidence found in the apartment, we heard from counsel when he was up there arguing. Really? What about this? What about these drag marks through the carpeting of that apartment that Ebony Wiley told us was not there when she was there with Felicia and was not there when she got back? Those drag marks are not there. And just to the left, you can barely see the little dot where the zipper pull was found, right next to these drag marks. The scuff marks on the porch, more scuff marks, and the wheel that came off the suitcase, that was all found in the apartment. Critical evidence identifying this defendant as the murderer of Felicia Williams. More scuff marks. These are on the laminate, wood laminate or wood floor leading out of the apartment. We know that the zipper pull found in those drag marks matched the suitcase in the defendant's car, and I say defendant's car, the Lexus that belonged to Calissa Kelly, the defendant's suitcase that was in the Lexus. We know they matched. We know that that suitcase had all of its zipper pulls and all of its wheels. So this isn't the suitcase used to transport her. But that is the suitcase that he lived out of, according to Calissa Kelly. And we know from the evidence, this is where the suitcase was when the Lexus was recovered on the night of the 17th. But that's not where it was when he picked up Felicia, because she happily jumped into the back passenger seat right where that suitcase is. Remember when I asked Calissa Kelly, did he keep the suitcase in the trunk? I guess I should have asked her, did he keep it in the back seat? Because then she would have said the trunk. But I said, did he keep it in the trunk? Yeah, no. You know, she's trying to figure out what's going to help the defendant. This woman who has stood by this defendant for 5 years, over 366 visitations with him at the county jail, over 2,000 collect phone calls with him from the jail, and has continuously put money into his canteen and wouldn't tell us how much, and apparently got a loan for some personal reason that may have been related to the defendant. We don't know. But in any event, that suitcase was not in the back seat when Felicia Williams got in. It was in the trunk where he kept the suitcase. So why is it in the back seat? Why is that wheel broken off of a suitcase on the porch? And why are all these drag marks and scuff marks? And we know the wheel matched the wheel of the suitcase from the back seat. Same brand of suitcase. We know from Captain Wool that suitcases are sold in groups of 2 and 3. We all know that. That's common sense, life experience. And they're sold in separate sizes, small, medium, large. We know that that suitcase that Felicia's body was put in, her 120 pounds caving in that wheel, and having to break off the zipper pull trying to drag it across the carpet, we know that suitcase that had her body in it, and probably a lot of her DNA, sweat, skin cells, that's gone. Never to be seen again. And we know the causeway was searched by water, by air, by sonar, torpedo, by going up and down by multiple agencies, Clearwater, Tampa Police Department, Temple Terrace Police Department, and never, ever found. Counsel talked about the soil. Why is it in the passenger seat? if it was in the trunk, if he put her body in the trunk, necessarily having to remove that suitcase and put it in the back seat so he could make room to put the suitcase with her body into the trunk, it had to be taken out of the trunk in that dark crime scene that he went to and sought out. And then her body had to be taken out while the suitcase laid on the ground. And then her body was thrown in. And if you're going to get rid of the suitcase, why wouldn't you put it in the front passenger seat so you could easily access it when you're leaving that scene and depositing it wherever you threw it, off the main span bridge, in some dumpster somewhere on the Rocky Point, on some dumpster somewhere on the way back to St. Pete? Maybe he put it in a dumpster when he stopped at a gas station to get a beer, like he told the detectives he did on the way back to Calissa Kelly's house after he dumped this little girl's body in the bay. Maybe that's when he got rid of it. We're never going to know, because of the lie that he spun through his mother and Ebony Wiley that gave him the time to destroy this evidence. Because this defendant is not just a rapist and a murderer, he's a master manipulator of these women that we've seen. He manipulated Calissa Kelly for her car. He manipulated Ivy Van, this poor woman who was in a soured marriage and in a strange situation, just ripe and susceptible for someone to sweep her off her feet, sending him money. Remember what she said? She sent him $150 that day, the day of this murder. I don't even want to think about how much money I've sent him over the last several months. And finally, Ebony Wiley, this 23-year-old girl that he swept off her feet, every one of them telling them he was going to marry them. He's telling Ivy Van on the way off the causeway, on that Rocky Point Tower, hey, you know what? I really want to pursue this. I don't want to just keep you at an arm's length dragging money off of you anymore. I want to pursue this. I want to come live with you out of state. All of a sudden, after he's murdered this little girl and dumped her body, he wants to leave the area and go live with her out of state. And remember what he told Corporal Staley in his interview? Or no, not in his interview, in his phone call when he lied about being at Williams in 301, when Corporal Staley said, hey, you don't come meet us at the Winn-Dixie. He didn't show up because he was at the Insta-Loan. He said, hey, when he called him back, I need a couple hours. I can't meet with you for a couple hours. Trying to buy himself more time. Corporal Staley wasn't having any of it. Insisted that he show up. And this defendant went because he knew they'd come after him. We don't know where that suitcase is. We couldn't give it to you because of his manipulation and destruction and cover-up of this crime. We know that wheel caved in because she's 120 pounds. This kid is 120 pounds, the size of a lot of grown women. Suitcases aren't designed for 120 pounds. The limit for carry-on is 50 pounds, I believe, for most airlines. There is no doubt in this case who murdered Felicia Williams. And counsel is right. Mr. Harmon is going to stand up here and tell you that we've proven this case beyond any doubt, and that it is crystal clear. You have heard evidence that interlocks, corroborates each other. Strong, powerful evidence, like the strands of a rope that build the strength of that rope. All of this evidence layering on top of each other and dovetailing and fitting into each other. This defendant is guilty, and there is a mountain of evidence that proves it. When he murdered this little girl, he did it alone behind closed doors. When he raped her, he did it in the privacy of his mother's apartment. When he sought out the darkness of the Courtney Campbell Causeway to dump her body like some bag of garbage, he sought out a dark, secluded area, one of only two on the entire causeway, according to Captain Lowell and Sergeant Spaulding. Captain Lowell told us when he went out there at night to visualize it, it was pitch black. Nobody could have seen him from the roadway, from the thoroughfare of the Courtney Campbell Causeway. And he selected that because you can see in those aerial photos wide open areas on both sides. But he went right to that location where she just happens to have been located, seeking out the dark. That's why he waited so long. The Temple Terrace, not the Doralos, apartments and Temple Terrace. He was waiting for the cover of night, for the cover of darkness, so he could put her body into that car, so he could dump her body on the causeway when there was less traffic. And then he found out from Ebony Wiley, I gotta go. The police are here and they're coming. So he took off and scooted out of there right underneath their noses. Not to their fault, based on his manipulation and deceptiveness. But now in this courtroom, in the light of this courtroom, in the light of all this evidence, he can't hide anymore in the dark, because we, through this evidence, have revealed these despicable, perverted acts that he committed on this little girl in this horribly brutal, violent crime. It's been revealed under the light for all of us to see it. He's not presumed innocent anymore. That has been stripped away. We have proven this case beyond any doubt. This evidence shines a strong spotlight right over here on this table. It beats a solid path across this courtroom and directly to this defendant right here, Granville Ritchie, right across this courtroom. Evidence that you can rely upon today, tomorrow, for the rest of your lives, to know that you are rendering a true and just verdict. This little girl is full of life. Her life counted, just like everybody else's. It counted. She was little, but she was still a little human being, and her life mattered. We have proven this case beyond any doubt. Granville Ritchie raped Felicia Williams, and he strangled her and murdered her. And there's absolutely no doubt of that.